Good afternoon, ladies and gentlemen. We're certainly glad to have all of you here. We're about to start the House Judiciary Committee. I think we got about 10 bills on. We will certainly deal with them just as economically as we can do so. So as we get started, Brady, how about call the roll? Let's make sure we got a quorum.
Hill.
Here.
Wadsworth. England. Almond. Bedsole. Chestnut. Faulkner. McClammy. Pettis. Robbins. Simpson. Standridge. Starnes. Stringer. Tillman. We have a quorum.
We have a quorum. Okay, we got a quorum going on today, and well, is Barfoot going to be here? Do you know? Okay. Senator Smithman, let me ask you something. If Barfoot doesn't show up, are you going to talk about his retirement bill?
I don't know if I'm, so when we was in meeting, I don't know if I'm kind of educated enough to really talk on it, because y'all might have some good questions. But you know what? The Lord answer prayers. I just want to tell you that. Because I was just talking to him, and I said, now, how can I get the word?
To the Lord or somebody in here?
No, I was talking to him. I was talking to him. I said, now, how can I get to this mic without interrupting this meeting? They said that, is there any way y'all can move me up? Because I'm trying to get y'all some confirmations at 2 o'clock.
Yes, sir. Okay, Senator Smithman, you win. And I don't, you go ahead. Your House, Senate Bill 34, go ahead.
Thank you, Mr. Chairman and committee members. Let me put my eyes on. I'll be doing like that, and y'all be saying, that word don't say that. Let's see, I want to make sure I got my numbers straight, Mr. Chairman. Yeah. SB 34, isn't that on the agenda? Because I don't have an agenda. All right, this bill, to kind of just sum it up to everybody, is that we passed a bill. We had a big situation a couple of years ago, if you all remember, the threats that was made on our Jewish synagogues and everywhere all around. And so at that time, you also graciously helped me pass a bill that would provide for protection for those terrorist threats, and even somebody else, one of y'all had to be able to deal with I think it was Representative Faulkner. He had to be able to deal with the penalties, the monetary penalty dealing with the damages. And so since that time, the judges approached me about and shared many situations where they have been receiving threats as well. And so because of that, that's what this bill grew out of, trying to extend that so that the judges would have that same protection. From that, what is Senator's name? Our tourism chair. I shouldn't be acting like I don't know his name. Upstairs. Anyway, well, y'all know him, the one that's handling the gambling bill upstairs. The chairman. Yeah, no, not the sponsor, but it goes into tourism. Price, Senator Price. So Senator Price approached me and said that the clerks and it was one other segment that they wanted to be included as well under this protection. So that's what this bill does. It protects them, it protects the judges from the terrorist threats that we've been addressing. So that's the essence of this bill.
Got a motion for a favorable report. Is there a second? Are there any really? I got you, Senator. Which one we've already done? Any questions? All in favor of a favorable report, say aye. Aye. Any opposed? Thanks, Senator.
Thank you all. Thank you, Mr. Chairman.
Senator Barfoot, you ready on 32?
Thank you, Mr. Chairman.
Yes, sir.
Committee members, appreciate the opportunity to be here. So SB 32 makes a small change. Current law in Alabama provides that an individual, once they've been convicted, if there is any restitution amount that's owed, and that individual who's been convicted has retirement through either the ETF or the general fund provision, state retirees provision, that those retirement benefits are subject to be taken for the benefit of the restitution amount. Lays out 3 different criteria, though, under current law, that the amount of restitution is ordered is over $1,000 or $1,000 or greater, actually, that the individual subject to order is a retiree or beneficiary of the TRS or the ERS. And then thirdly, the case has been assigned to the District Attorney's Restitution and Recovery Division. And what we've seen is, through the past, is that they have to be 90 days in arrears before the DAs are able to start getting that restitution back. This would just take out that provision to where that victim can be compensated without the necessity of having that delinquency status.
Thanks. All right, any questions? Does anybody? Motion for a favorable report, is there a second? All right, are there any questions? Seeing none, all in favor of a favorable report, please say aye. Aye. Any opposed? Senator Barfoot, thank you so much.
Thank you, Mr. Chairman. Thank you, committee members.
Ladies and gentlemen, House Bill 100, Representative Clark has asked me to carry that over and put it in our criminal subcommittee. And so we are going to do that. And this is about dealing with individuals who make threats against either poll workers or people operating within our voting sphere. So she has asked me to carry that over and put it in our criminal subcommittee, and I'm going to honor that request. So that's HB 100. HB 165, Representative Brown, you ready?
Thank you, Mr. Chairman, members of the committee. This bill we had a public hearing on 2 weeks ago. It's House Bill 165 that changes the age of consent for vaccinations. Currently, anyone that's over the age of 14 can walk in and get vaccine without parental consent. And what this does, it provides that any minor must get a written consent from a parent or legal guardian to get any type of vaccination in this state.
Now, do you have it, is there an amendment on here, or are we going to put, okay, go ahead. Let's talk about the amendment real quick.
Yes, sir, Chairman, I have an amendment.
Okay.
It says replace lines 33 and 34, correction, you back up. Replace line 20 on page 1 with the following. Guarding for any minor to receive a vaccination to provide exemptions. Replace line 33 and 34 on page 2 with the following. Vaccination for himself or herself unless the minor is I, not dependent on a parent or legal guardian for support. 2, living apart from his or her parents or from another individual's acting in loco parentage. And 3, managing his or her own affairs.
Are there any questions about the amendment? Is there a motion to adopt that amendment?
Motion.
I'm sure, no, Mr. Stringer, you made the motion, didn't you? Sorry.
I'll second.
Thank you, Mr. Standage, I appreciate it. There's a motion and a second to amend the bill as you have just heard. Are there any questions on the amendment? And all in favor of the amendment, please say aye.
Aye.
It's amended. Back to you, Mr. Brown. Is there anything else you want to tell us about it?
No, Mr. Chairman, I think I've worn it out.
Do you have a question? Yes, ma'am, go ahead.
I just wondered, of course, all this was before the break, so my brain is unclear or foggy. Some might argue that that's not the only reason my brain is unclear or foggy, just because of a break. But anyway, I remember that there was some concern or discrepancy about the federal law with regard to this. And can you just tell us what you've discovered about that?
Well, on the federal law, I have a sheet. Actually, I should have given that to you, Representative. I apologize. That shows how many times that has been amended nationwide. And in fact, we on the federal law, we recently passed 2 years ago dealing with sexual reassignment surgery for minors. And that in itself shows that the federal law really doesn't have standing in this, because if it was requiring that we couldn't change the age of consent from 14, we wouldn't have been able to do that. And so there are multiple states in fact, there's 41 states that require parental consent for vaccinating minors below the age of 18. So there's 41 other states that have requirements for parental consent under the age of 18. So we're just looking to join and be number 42.
There is a federal law similar to what was discussed.
Well, yes, and this was put in place in 1973. So since 1973, there's been 41 states that have essentially adopted their own age of consent different than what was the federal law for 1973. So it is amenable because, like I said, there's been 41 states that have done it in the past, and we recently did that 2 years ago with the gender reassignment surgery.
So I believe I read an email that suggested that the federal law was more narrowly tailored. Is that the case, or no? Is it more a broader?
If you read the federal law is actually geared more towards minors being able to get mental health care and being able to get treatment for STDs and that sort of avenue versus dealing with vaccinations or general health care. That's what the intent was on the federal law. But it is amenable because, like I said, there's 41 states that have done that. So.
Thank you.
Any other questions? Robinson, did you have one? Sure.
I had a quick question. So the way I'm reading this amendment, it now says that, because before the bill read that an unemancipated minor may not give consent, but it allowed, the written consent of a parent or legal guardian. But now the way it's written, we don't allow for the consent of a, because we eliminate that because we say the vaccination for himself and herself unless the minor is 1, not a dependent, 2, living apart, or 3, managing his own affairs. Do we need to still include that they could get written consent from the adult? Because that eliminated that from.
I think that's I understand what you're saying, and on that too, that is geared towards situations where
Well, the minor's actually acting as an adult,
right,
making their own decisions.
Right.
But we don't have in here anymore where it says that with, right here it says without the written consent of a parent or legal guardian, but by that statement it's saying that the only way the vaccine could have been administered was with the written consent of a parent or guardian. Well, now we're just saying it can only happen as if the minor meets one of these 3 conditions. So should we say, those 3 and with the written consent of the guardian? So that way it's clear that the guardian could consent to the vaccination if you are not one of those.
Yeah, I see what you're saying.
And then if you're not if not an independent minor, your parent can still consent to the treatment.
I'm amenable to that. Yeah, I understand totally what you're saying. I mean,
To clarify, you have to meet all 3.
Right, you have to meet all 3.
or
right.
it doesn't say or. Yeah.
Right, but what I'm saying is what it's saying is an unemancipated minor may not give consent to the administration of a vaccine for himself or herself unless, so it's saying if for those 3 things, if you're an unemancipated minor, you can give consent. But what I was saying, if you're not an unemancipated minor, we don't say anymore because don't we eliminate line 33 and 34, so we eliminate that part about getting consent from the parent or guardian, right?
Let me ask you something, Ben. Are you saying that what should happen is his amendment should simply be tacked on to line 34?
That's what I think.
In other words, leave.
I
And not
think,
do
yeah.
away with,
34
Just
as is
don't-
and
right.
Add in
Add
after
it.
34.
That's what I'm, yeah,
Following.
that's what I'm saying. Leave it as written and then just add it. So that way we deal with if you are an unemancipated minor, and then underneath that, if you are an emancipated minor, here's what happens. So that way we take care of both. So don't
sure.
So I guess what I'm saying, yeah, what Judge is saying is instead of replace line 33 and 34, just add it, line 35, insert it there.
Can we clean that up, Bray? Pretty easy.
I mean, we've already amended it, so we need to amend the amendment, tack it on.
Or could we do a motion to reconsider that amendment
Yeah.
and then?
All right. How about, I'll accept a motion to reconsider the amendment. Is there a second? And there's a
Second.
All in favor, say aye. All right, so now we're back. So now let's get the amendment as it needs to be, Chip.
Okay.
Mr. Stringer, you okay with that? Okay. I should ask you before I started down this road, shouldn't I? I apologize. How about let Mr. Stringer do it. It's okay, Ben, let's let Mr. Stringer do it. He started this thing, and I would like for him to be the one who amends it. That's all right. Not a problem. No. No, it's easier to stop it here for 10 minutes than it is get it on the House floor and have it stop for an hour while we try to figure this out. You okay, Chip?
Yeah, Judge, I appreciate your thoroughness and Representative Robbins on this, because
Here, let me read it. Representative Stringer, make sure this reads how you want it. So currently, as the bill is written, subsection B, notwithstanding subsection A, an unemancipated minor may not give consent to the administration of a vaccine for himself or herself without the written consent of a parent or legal guardian. And then we would add the following language. Additionally, an unemancipated minor may not give consent to the administration of a vaccination for himself or herself unless the minor is, and then we've got those three factors that we just discussed. And we can get LSA to clean that up. Is that
Yes,
how
sir.
You good with it?
Yes, sir.
Hey, y'all have heard the motion. It's really just adding that.
I make a motion that Prince read the amendment.
The whole bill.
I will allow you to withdraw that motion. Thank you.
I withdraw the emotion.
Mr. Stringer made the motion to amend. Or is there a second to the amendment? Mr. Sandridge, okay. Are there any questions about this? I know we've sort of strung this together, but I think we've gotten what you want to do with it. All right, all in favor of the amendment, say aye. Aye. All right, now it's back to you. And is there a motion to?
Mr. Chair, make a motion for a favorable report.
Favorable report is amended, and there's a second. Any questions? All in favor of a favorable report, of giving this bill a favorable report as amended, please say aye. Aye.
thank you, Mr. Chairman.
Thank you, appreciate it.
Thank you, members. I appreciate it.
Representative Stubbs. This is House Bill 92.
House Bill 92. Thank you, Mr. Chairman. Thank you, members of the committee. This House Bill 92 is related to asbestos litigation and overnaming defendants. We have worked diligently with both the proponents and opponents of this bill over the last several weeks and probably over a month, and been able to come to an agreement. And the substitute that is presented today is the result of the agreement between both sides. The bill primarily focuses on limiting the extended list of defendants and putting small businesses and others in a position where they have to access liability insurance and retain legal counsel, and then subsequently at a later time, they are dropped as no longer being part of the litigation. The substitute has some changes in terminology from plaintiff to exposed person, along with the other agreed upon changes between both the proponents and opponents of this bill. So with that.
Good deal. Listen, I think the first thing we need to do, though, is adopt the sub. Is there a motion to adopt the sub? Thank you. Is there a second? Thank you. We got a motion. Tim Wadsworth. Motion and second to adopt the sub. Are there any questions from the committee? Okay, seeing none, all in favor of adopting the sub, please say aye. Any opposed? Now we are back to you as an adopted substitute. So where are we now? Is there a motion to give the bill as adopted, as substituted, a favorable report? And okay, we got a motion and a second. Any questions? All in favor, please say aye. Any opposed?
Thank you very much.
And I tell you this, we all appreciate, we appreciate your hard work, because I know this has been several weeks, and I know you've been through a lot with a bunch of different people, and we sincerely appreciate it.
I appreciate it. I have to do legal, I'm related to a bunch of attorneys I feel left out at home, so I try to get involved as much as I can. Thank you.
Yeah, right. Okay, yeah, House Bill 182, I think Representative Lipscomb's got somewhere that he needs to be, so let's see if we can get him.
Thank you, Chairman. I appreciate the bump forward. As you know, this is the second iteration of this bill we brought to you a couple of weeks ago, and there were some comments and commentary that demanded that we create a substitute for it, and that should be before you now. And if I may, I'll try to summarize that for you.
Please do.
The bill sets an efficient process for removal of squatters from a house. The sub increases information required of the property owner in the affidavit to protect legitimate occupants and requires owner to provide a 24-hour notice. The sub also makes clear several crimes, including the fraudulent sale of or lease of real property, $1,000 worth of damage to property by a squatter, and that filing a false affidavit by anyone is not only a crime, but also creates a civil cause of action. In addition, the sub firms up the language protecting law enforcement from liability. Additionally, it makes clear that squatters do not fall under the landlord-tenant law.
So you've heard a summation of the substitute bill. Is there a motion that we adopt the sub? I'll make the motion we adopt the sub. Is there your second? Okay. Are there any questions on the sub? All in favor of adopting the substitute bill, say aye. Any opposed? So it's now back to you, Mr. Lipscomb, your bill as substituted. Is there a motion to adopt the sub? Thank you, Mr. Stringer. Is there a second? A favorable report for the sub, yes. Okay. We got a motion and a second to give the bill as substituted a favorable report. Are there any questions on it? Seeing none, all in favor of favorable report as substituted, please say aye. Any opposed? And Mr. Lipscomb, same thing that went for Representative Stubbs goes for you. I appreciate it. I appreciate the fact that we make a real effort to clean these up and get them in a position where when they go to the floor, they are as clear and concise and coherent as we can make them. And I think you've done a good job, and thank you a lot.
Thank you, Chairman. Thank you, members.
No pressure, Mr. Moore, but it's your turn.
Thank you, Mr. Chairman, committee. First off, I want to thank the chairman for allowing this to go to subcommittee and for y'all's help in assisting in cleaning this up and in tightening it. But this bill would include the touching of any part of the body for sexual gratification in the meaning of the term sexual contact for the purpose of the crime of sexual misconduct.
Are All right, so is this a substitute?
It is a substitute.
All right. Is there a motion to adopt the sub? Is there a second? Second. We got a motion and a second to adopt the sub. Are there any questions on the sub? Yes, sir, Mr. Ward.
Yeah, just, we went to the subcommittee and we actually ended up not making a change to it and just kept the original substitute in there.
Okay. All right, is there a motion to give the bill a favorable report?
So moved.
Thank you. Is there a second? Second. We got a motion and a second. Are there any questions on this? All in favor say aye.
Aye.
Any opposed? Okay. Mr. Moore, again, same thing I've told the others. Thank you a lot. I realize y'all went through a lot of work to get these things done, and it does. We appreciate the effort. We really do.
Thank you, Mr. Chairman. Thank you, committee.
Mr. England, House Bill 200. If you want to stay there, Mr. England, you can. I mean, I don't see any reason at all for committee members to walk down there. We all know who you are.
As long as Matt doesn't harass me.
I can't.
I think I'm far enough away from the stick. I'm all right.
Ooh, wow. I need to move on. This is House Bill 200, and what it seeks to do is take existing law in regards to notifying family members of autopsies, or who family member has gone through an autopsy, of notifying them prior to retaining and organs, and it takes the current law and it adds a penalty to it. So we can notify those that are in these positions to make sure that they have obtained the proper authority and notified the family prior to keeping organs after an autopsy.
Is there amendment on this one, Mr. England?
And I'm glad you asked me that. So it reminded me that I've had extensive conversations with Angela Delamana and also with UAB. At this time, we're not going to adopt the amendment, but we're going to further work to make sure that as this bill works its way through the process to minimize any unintended consequences from it. So you may, as it stands today, you may see a different version of this bill down the road, but right now we're still kind of working through some issues.
Okay. Mr. Simpson.
Mr. Chairman, I make a motion for a favorable report.
Thank you. Second. There's a motion and a second for a favorable report. It's not being amended today. Is everybody, I know you got one in your packet, but it's not being amended
Right.
today.
And we've talked about that, the amendment. Yeah.
Thank you, Mr. England. Seeing no further comments, all in favor of a favorable report, please say aye. Any opposed? Okay, Mr. England, thanks a lot. Next bill, Mr. England again, House Bill 32.
Let's keep that same spirit. This is House Bill 32. We had a pretty spirited public hearing on it maybe a couple of weeks ago. And what this bill does, it seeks to further define for purposes of felony murder what accomplice liability is, in an attempt to cover the individual in the event like you've got two people who commit a crime together and an intervening third party may hurt, shoot, stab, kill one of the who would potentially be a co-defendant. And this bill would attempt to clarify for that situation that the felony murder statute wouldn't include the potential co-defendant. So with that, Representative Robbins contacted me early this morning, like early this morning, with an amendment, and I think the spirit of it is good, and I would consider it a friendly amendment. So at this time, if he wants to introduce that.
Ms. Robbins, how about talk to us about your amendment then?
Basically, my amendment is to not eliminate felony murder as a charge, not eliminate it, but would say that if you read it, replaces lines 71 through 74 on page 3 to state that a person is immune from prosecution under this subsection if the individual killed was a willing participant in the underlying felony and the defendant did not possess a deadly weapon or dangerous instrument, did not know that the individual killed possessed a deadly weapon or dangerous instrument, and 3, did not reasonably believe the deadly force would be used during the commission of the underlying offense. So it just, and then there would be, you'd have those elements that would need to be proven. And then on top of that, you would have a pretrial hearing to give the judge discretion on whether to grant that immunity or not. And you, as the prosecutor, would have to prove by preponderance of evidence that he or she has satisfied paragraph 1, which are those 3 elements. So it would just clarify a little bit and add and not take away the felony murder. It would not eliminate it from the code.
All right, if I read what you just, let me just ask you this. In number 3, after a pretrial hearing, the court concludes, and you said the prosecutor, but you meant the defendant. So you're shifting this. This is
Right,
like
you're right, you're right.
affirmative defense, isn't it?
It's affirmative defense. It's basically we copied just from like the stand your ground law. It's exact same, if not exact same, but very similar to stand your ground. You'd have a pretrial hearing just to determine, and it would shift the burden to have to prove that. And it would be up to the judge to decide if the individual had knowledge that a death might occur or that he or she had a dangerous weapon and that he or she had knowledge that the co-conspirator had a dangerous deadly weapon.
So Mr. Robbins has offered that amendment. Mr. England has said it was a favorable amendment, so I'm going to consider that a second. And now I will take any questions on the amendment. Yes, sir, Mr. Bedsole.
Yes, sir. Mr. Robbins, I want to make sure I understand because I think we heard some very important testimony from District Attorney Matt Casey when he was explaining that the burden was lying on the District Attorney's office to connect the individuals together, but also that they were that the accomplice that was not killed during the course of the commission of the crime reasonably knew. So explain to me so I understand that how this shifts that burden of proof in a similar situation to what he described.
It shifts it for the pretrial hearing. So there, in terms of actually proving the case, the prosecutor would still have to prove the case, have to prove that the underlying offense occurred. But what we're trying to say is that on the front end, on whether or not that charge, you would have a pretrial hearing on the affirmative defense that, one, I didn't know. As you can see, I had no weapon on my person, no dangerous instrument, one, and I had no knowledge that a death might have occurred from the underlying offense, and I had no knowledge that anyone that I was with that they had a dangerous weapon. And if that's the case, under that fact pattern, a judge could decide that you could not proceed with the felony murder charge. But it would be on the defendant to have to prove those things in the pretrial hearing. And then if the defendant cannot prove that, or without a preponderance of evidence at that pretrial hearing, the judge could then, it would then proceed to, grand jury and a trial. But it's so it doesn't eliminate the need for the district attorney to still prove their case.
Okay. So in essence, would this really make it a little bit easier for the district attorney?
I mean, I think that I'm not sure if it makes it easier or harder, really. I mean, I think that it just creates elements for a defendant, so they could argue that you have to meet these certain elements to establish that for felony murder.
Okay, thank you.
Okay, we got a motion to adopt the amendment. All in favor of adopting the amendment, please say aye.
Aye.
Any opposed? Okay, the amendment is adopted. And Mr. England's back to you.
Judge,
Sure.
ask for a roll call on final.
On final? Sure, no problem. There's been a request for a roll call vote on the final as amended. You're talking about the bill as amended, aren't you?
Yes, sir.
Sure, that's what I thought. All right, is there a motion to adopt the bill as amended? Okay, second.
I'll second.
Okay, we got a motion and a second to adopt the bill as amended. Mr. England, you got anything else to say?
Let's get on with the voting.
All right, that's a good idea. Okay, go ahead, Brandy.
Hill.
Yes.
Wadsworth.
Yes.
England.
Yes.
Almond. Bedsole.
No.
Chestnut.
Yes.
Faulkner. McClammy. Pettis.
No.
Robbins.
Yes.
Simpson.
No.
Standridge.
No.
Starnes.
No.
Stringer.
No.
Tillman.
Yes.
Okay, it does not get a favorable report, Mr. England.
Thank you, members of the committee. Roll Tide.
Roll Tide.
What a perfect way to end a losing bill, but we will not go there. All right, Mr. Simpson, let's talk about, this is another one that you guys have done a lot of work on, and I appreciate it.
All right. So if you guys remember, we had Judge Honeycutt come in last week or whenever we were here last and talk about the basis of this bill to be able to allow judges to require a child to be taken out of the custody if they feel the child is in danger, placed in the custody of either DHR or a responsible family member if they feel the child is in danger based on what happened from those deaths in Mobile. We have a substitute to that bill which has been worked through. We've got DHR and the Judges Association that are here. That's why I'm standing down here, because in case I need to ask questions, I'm going to be able to lean over to them.
Gotcha.
So what we have with the substitute was language that they kind of came together to make sure we didn't have any unintended consequences of messing some things up for other orders or anything from the future. We have a substitute, and we also have an amendment to that substitute, and that amendment to the substitute is not the one you had in your packets. It is an amendment that we created about 5 minutes ago with LSA and Ms. Casey Bates. So I guess the first thing...
It's been handed out.
It's been handed out now, yes.
I thought it was handed out.
So the first thing I would do is make a motion to adopt the substitute, which is in your packets as a sub to HB 137.
Okay, you've heard that motion to adopt the sub, and we have a second? All right, good. So all in favor of adopting the sub, please say aye.
Aye.
Any opposed? All right, your sub is adopted.
Now I have an amendment to the sub, and the amendment, if you look at the title on the top, is 5NGI3M3-1, and that has today's date on it. And that amendment to the sub was created by DHR and the Judges Association, again, to make sure that there were no issues crossing lines or with jurisdiction or how to make sure the child is safe the best way possible. So at that time, I would offer the amendment to the sub.
Second.
Okay. And so really what the amendment to the sub, if I've got it right, is it allows a circuit judge to do exactly what you're saying, but then puts it back into the purview of the juvenile court to make sure it's like a 72-hour type hearing, right?
Correct. What we didn't want to have happen is the order just be staying out there, and they're either stuck with a family member or DHR with no way to come back in front of the juvenile court.
That makes sense. I got you. So all right, there's a motion second to adopt the amendment. Are there any questions on the amendment? Seeing none, all in favor of the amendment, please, of adopting it, please say aye.
Aye.
Okay, Mr. Simpson, your bill as substituted and amended is back to you.
At this time, I'll make a motion for a favorable report.
Okay?
Second.
Second. All righty. Any other discussion? All in favor, say aye. Aye. And all opposed, say no. So you got a favorable report as substituted and amended. Okey-doke, Mr. Wadsworth.
We've got HB 228. This is an ALI bill, and what it's doing is doing two things. One is clarifying things that are a little unsure, and also trying to make it where different businesses will incorporate in Alabama versus incorporating in Delaware. And it also just clarifies different things. This particular bill goes through and it makes, there was a question whether or not a registered agent had to be located in the state of Alabama. This makes it where, and clarifies that a registered agent has to be located in Alabama. Also, it requires that the street address, county, and the registered office is identified and located in Alabama, and makes it easier for entities that were professional corporations to let them know that they're governed by the Alabama Business Corporation Act on it. But it just basically allows, when you have a situation where different methods are void or avoidable, it allows those particular agreements an easier method to get them ratified. But basically, it's basically a cleanup because in the past we've done the Alabama Business Corporation Code and the Alabama nonprofits, and we did that last year, and this is part of that same attempt to do that.
All right, so Mr. Wadsworth, it's your bill, so I assume you are making a motion for a favorable report. Is there a second?
I'm making that motion.
Okay, is there a second? Thanks. Does anybody have any questions on this?
I do. What's on, could you talk to me about page 142? I'm just joking.
Okay.
But I have a motion because of what you just did to me on my bill. I want a motion to have this bill read at length by Prince Chestnut.
Second.
Okay, if anybody wants to vote in favor of that, you're excused. Otherwise, as the nays have it.
Nays have it.
Now we have a motion and a second to give this bill a favorable report. Is there any other questions? Seeing none, all in favor say aye. Any opposed? Thank you, Mr. Wadsworth. I appreciate it. That concludes this meeting. Thank you all for coming. Appreciate you very much.